All right. Welcome back, everyone. And by welcome back, I mean you can continue enjoying lunch, but we are going to start talking at you. So I'm delighted to be moderating and presenting on this panel, Animals in Harm's Way, Legal Arguments and Hands-on Intervention, wherewithin we'll be talking about all the different ways that people can try to intervene with animals in a direct fashion and the legal implications thereof. I am David Rosengard. I am a managing attorney in the Animal Legal Defense Fund's Criminal Justice Program. I'm also an adjunct professor of animal law at Lewis and Clark Law School. And I am thoroughly delighted to get to hang out with all of you and with my co-panelists, one of whom will be on a screen, the other of whom is here, and I will introduce them quickly before we begin. So first we will have Mary Corporon. Mary has a practice that focuses on criminal defense, domestic, family, and juvenile law, as well as general jury trials. Prior to joining the current firm she's at, Christensen and Jensen, she was a shareholder with Vancott, Bagley, Conwell, and McCarthy. She has been elected to the American Board of Trial Advocates and has been recognized by the Mountain State Super Lawyers for white collar, Dewey, and general criminal defense. And also, in a feat that few attorneys can boast, she has not once but twice had cases reported in the nationally syndicated column, News of the Weird. And Vanessa Shakib is an expert in animal law, government accountability, and illegal business practices. Those of you who were here for the student convention yesterday heard her speak at length about her passion, skill, and success in suing the federal government for failing to do what they are supposed to be doing. Her work has been featured by many media outlets, including the LA Times, the New York Times, The Guardian, Science Magazine, and more. And she co-founded and co-directs Advancing Law for Animals, which is a nonprofit law firm for the benefit of our non-human friends. She develops impact litigation to further the interests of those animal friends that are exploited in research and industrial food production. She is also an adjunct professor of law at Southwestern Law School, where she was awarded the SBA Adjunct Professor of the Year Award. And with no further ado, to give us plenty of time for Q&A, I will turn things over to Mary, who will be on screen.
Good afternoon, everyone. I wanted to make clear when someone asked me to appear in this panel that I'm afraid I'm here at this conference and on this panel sort of flying under false colors here. I would not call myself an animal rights activist or an animal law specialist. The lapel pin that I have that I sometimes wear to court says, save the human. And that's my background is criminal defense work. And in that background, I have represented many people over the years and have come to understand how incredibly unfair and biased and not like it's described in civics class, our criminal justice system can be. And I think I'm on this panel because I was defense counsel for Paul Picklesheimer in a case involving a couple of piglets and Smithfield Farms in Beaver, Utah. And at the conclusion of the jury trial with a jury from Southern Utah, which is an extraordinarily conservative part of the country, we had a not guilty verdict for Paul on 2 counts of burglary for an event in which he was with some folks who took some piglets out of a Smithfield Farms facility. So I suspect that's why I'm here. And I want to say that what first hooked me into that case and got me involved in the situation was my concern that Paul was looking out for a couple of piglets or an entire farm full of pigs, and somebody needed to look out for Paul. I was very concerned when I began to read the news reports and to hear the story of what was happening with that prosecution, that the prosecution was being handled in a way that was really quite extraordinary compared to how typical burglary cases are handled. I've defended burglary cases before. I've been burgled myself. I know that when I pick up the phone and call the police and say, I've just come home and found my door kicked in and my house burgled, which has happened to me once, that 8 FBI agents did not set about attempting to figure out who had broken into my house and who had taken the cash out of my dresser drawer and who had taken the jewelry out of my jewelry box. And no FBI agents certainly were spending time, 8 or 10 months later across 5 states looking for my missing jewelry, which is actually what happened in the Smithfield Farms, Beaver County, Utah case. So I was really concerned about what seemed like a very bizarre and unusual approach to a prosecution that was very, very harsh in terms of how it was directed against the people involved in that situation. And I am always very concerned from a criminal defense perspective and a civil rights perspective when the government steps in to prosecute one group of people more harshly than another, and especially if it's because the government just doesn't like their political viewpoint or their social viewpoint on some topic or other. So that's what hooked me into this case, was the very unusual nature of the prosecution. And that was something that concerned me. The written material that I have submitted on this was the set of jury instructions finally given to the jury in that case. And first of all, if you suffer from insomnia, this would be a great relief for you, I think, to attempt to read through this some evening. But if you are interested in how the case in Utah was presented to a jury, from my perspective, it was presented straight up from the playbook of Criminal Defense 101. It was not, I did not raise any right to rescue issues. I did not raise any animal cruelty issues. I took a step back and looked at what I think every criminal defense attorney does at the beginning of a case. Get out the statute, look at the elements of the statute that's been charged against someone, in this case, burglary. What are the elements of the statute? The government has an obligation to prove, by proof beyond a reasonable doubt, each and every element of the offense charged. And in this case, there was, I thought, a viable theory that they couldn't meet one of those elements. And indeed, that's what the jury decided, that they simply hadn't met one of the elements of their defense. So maybe in terms of other defenses of similar cases, I guess my first advice is, don't forget to just be a competent criminal defense attorney and go back to basics, because the government, thank heaven in our system, government still is supposed to have the burden of proof by a very heavy burden, and they're supposed to meet that burden with admissible evidence. And there are many times, surprisingly, when they can't do that. So that's kind of my view of why I think I'm here. And if anybody has any questions or any thoughts, I'd love to hear them.
Hi, everyone. I'm Vanessa. It's really an honor to be with you today at this event with my co-panelists, with my colleagues, and so many people I'm also thankful at this point to call my dear friends. So we're going to take this conversation and we're going to twist it around a little bit, because typically as animal advocates and as animal lawyers, generally what's happening is we are trying to advocate for the interests of animals owned by somebody else, by a third party. That could be an individual, it could be a business, it could be the government. And that's generally what I do in my work. I come up with creative legal strategies to improve the welfare and the lives of animals belonging to others. In my case, belonging to businesses operating laboratories and factory farms. So this is typically the dynamic that we're dealing with. Cedar's case, though, is quite different, because in Cedar's case, we have this dynamic and we're turning it upside down, because Cedar belonged to a little girl and her mother, my clients. Cedar was their property. My clients had every right to save his life and to do as they wished with their property. But what happened? We had a long list of government actors who dropped the hammer, who acted as judge, jury, and executioner, and who stopped at nothing, including violations of the Constitution, to make sure that Cedar was slaughtered and served at a government barbecue. So let's take a look. I forget that I have a slide here today. So when we think about Cedar's story, and here, this is a heartwarming picture. You see a child who loves her animal. Cedar has become a member of her family. So when you hear about this case, and we're going to dive into the particulars in a moment, but when you hear about this case, it is this classic story, textbook example of government gone rogue. But here's the thing. If we drill deeper, if we go down one more layer, we see that there's something more going on here, a powerful nexus between industry and between government. Now, Mary started tapping into this when she talked about the FBI response to the piglets in the Smithfield case. Glenn Greenwald, while he was at The Intercept, wrote a very powerful piece describing what he described as a 6-car armada of FBI agents armed with bulletproof vests, wielding warrants to get these sick piglets who had a $0 value to industry. These are not isolated events. The dynamics in the FBI hunt for these piglets very much mirror what happened to Cedar, but it also mirrors something that we are seeing happen nationally. For example, in states across the US, we are seeing ag laws, which thankfully colleagues here have been challenging, but we are seeing laws that violate the First Amendment, seeking to criminalize whistleblowing of any reports of abuse coming from factory farms. This is government coordination with industry to propagate the industry. At the same time, we've been seeing regulatory and legislative efforts to censor words like meat or dairy or cheese on plant-based products in violation of the First Amendment. This is an uncomfortable coordination of industry and government. So when we talk about Cedar's case, this might seem like a small town story of cronyism and corruption, and you're right, it is. But it's also pointing to a larger trend that we're seeing across the United States. And what's interesting, as animal advocates, we're used to being told by industry, this is our property. We will do with our property as we wish. Yet, as you'll see in the case of my clients, even with Cedar was their property. they could not rescue him from slaughter. And I think, again, this story is told as a microcosm. It's a local story, but it has reverberated nationally because of this puzzling response of government in lockstep with industry. So let's take a closer look at Cedar's story. Some of you might know the details, and why is that? It really reached viral news coverage, national attention, in fact, global attention. And it really started with an expose written by Sam Stanton of the Sacramento Bee, because like so many of us here, Sam was scratching his head. How is it that there are 3 sheriff's officers intervening in a purely civil dispute over ownership of a little girl's goat at a kids club? How is it without any probable cause these officers are getting a warrant to seize Cedar? So what Sam Stanton did from the Sacramento Bee is he did a Public Records Act request, and he really did a deep dive. He went and he calculated all of these sheriff's officers driving hundreds of miles to seize this little girl's goat. The cost of gas alone far exceeded the amount of money that the fair itself was out. So this is not only a failure of priorities, it's indicating something deeper here that really did shock the country. And so if you're not familiar with Cedar's story, let's dive into the facts a little bit. And this is actually, it's very exciting for me because generally I don't tell the story to a bunch of lawyers and law students. So I generally glaze over a lot of the details, but I think as lawyers, as students of law, you can really understand the egregiousness of the constitutional violations here when we walk through some of the facts of the case. And mind you, since this story's viral news coverage, we've had the benefit of some discovery. Discovery is still ongoing, but we have pieced together more as to exactly what happened to Cedar. So I will briefly lay out the facts if you're not familiar with his story. We have a 9-year-old goat who purchased Cedar to participate in a 4-H program. As many of you know, 4-H is a kids club with a very unhappy ending. It involves children who purchase animals, who own those animals, who raise those animals, and they ultimately live auction them for slaughter. We're talking about terminal auctions where the animal isn't given to the person who had the highest bid. The animal is put on a truck. The truck drives to the slaughterhouse. The animal is slaughtered. The winning bidder receives the meat. So this is the deal. A lot of children and families, of course, have a hard time in this program because they fall in love with the animal. This is normal and natural. We're a country of pet lovers. I'm sure you all understand that anyone could and would fall in love with the animal that they are bottle feeding and caring for daily. This is exactly what happens here. And so when it comes time for the youth livestock auction, my client decides Cedar's a member of the family. She doesn't want him to die. So here's a fun moment for the lawyers in the room. California has a statute specifically protecting minors. California grants minors the right to disaffirm any contract. But let's forget that very favorable statute. Let's just talk about basic breach of contract, where the remedy is mostly, except for very unique circumstances. What is the remedy? Anyone want to yell it out? What's the remedy? Monetary damages. All right, so we have a little girl who has a statutory right to walk away from this youth livestock auction. But even if she didn't, anyone can breach a contract. All you do is you make the other party whole. This is simple stuff, right? This is what we learned in our first year of law school. Easy peasy, 1, 2, 3, not much to it. The story should have ended when my clients took Cedar out of the youth livestock auction. Mrs. Long, the mother, sent a letter to the government fair, very clearly stating, I will reimburse you in any amount for the damages here. The story should be over, but instead we have government officials terrorizing my clients, threatening them with felony theft. I mean, I myself, I'm a lawyer. I would still be terrified if a government official was calling me, texting me, and threatening me with a felony. In this whole process, Cedar's temporarily placed somewhere safe, a few hundred miles away. Mrs. Long again, she types up a letter. And she's very clear, and she very smartly walks through the fair rules. Hi, this is my daughter's goat. The fair rules are clear. Exhibitors must own the animal to participate. The fair rules are very clear. The exhibitor retains ownership throughout the entire event. Cedar is our property. We have removed him, and we will pay for any damages. And the best part of the letter, and what's so legally critical here, is that she's very clear to say, this letter is in anticipation of litigation. This is very important because this is, and again, it should be obvious that this is a civil dispute, but if there were any doubt or confusion about it, this really seals the deal that we have a property dispute. It is not criminal. So what we knew when we filed the case was that the government fair officials received this letter of a civil claim and notice to sue. What we didn't know then was whether the sheriffs had ever received that letter. We now know through the benefit of discovery that the sheriffs involved had all received that letter, yet they omitted that letter when they applied for a criminal warrant to search for and seize Cedar. This is a material omission. We have sheriffs who are intentionally omitting evidence indicating a civil contractual dispute. We have the material omission of evidence that negates the presence of probable cause. Yet these sheriffs went forward seeking a warrant anyway. This is a constitutional issue. You need probable cause in order to obtain a warrant in a criminal matter. The facts around the warrant itself really are concerning. These sheriffs, there was about 3 sheriffs involved from Shasta County, other sheriffs involved down in Napa. A total of 5 officers are involved in obtaining a warrant and seizing a child's goat. The warrant here, as Sam Stanton so carefully reported, was quite lengthy. It included surveillance and photos of the location where they suspected Cedar to be. It included a provision allowing them to breach doorways and enter to retrieve Cedar. This truly went down like a drug bust. And here's the thing, the constitutional violations really don't end there, because in the first place, there's no probable cause to pursue a criminal warrant in a civil matter. But let's humor it for a second. These officers have this warrant. They drive hundreds of miles late at night to seize Cedar. Once they have him, they are on notice of a civil property dispute. My clients had the right to notice and an opportunity to be heard in this matter. But instead, what happened is the sheriffs acted as judge, jury, and executioner. They took it upon themselves to adjudicate ownership and to turn Cedar over. And unfortunately, he was slaughtered and, as we understand, served at a barbecue. The story is so heartbreaking that it really went viral in a way that's unbelievable. This was covered by every major news outlet. We had many national news segments. We were covered by CNN, Fox News, the New York Times twice, including the print edition, the LA Times front page print edition, right under the news of Trump's indictment. This was really big news. And when I think about why, we could spend a whole panel talking about why this was so newsworthy. But I think one big factor is this story is microcosmic of a larger theme of the inappropriate and unlawful coordination of government with industry. It's really a part of a larger trend. So Cedar's story, not only was it all over the news, it was all over Twitter. Just the top 3 tweets alone about Cedar had something more than 16 million impressions. And I think as animal advocates, this really strikes me, because animal law is this amazing 2-for-1 special where we have the opportunity to make the case for animals in court. And we also have the opportunity to make the case for animals in the public square. And so I think the newsworthiness of this story is worth taking note of, because we had families across the country and even around the world talking about falling in love with an animal intended to be eaten. And I think that here as lawyers, it's our job to maximize the laws that we already have, right? We all know that there's laws that either aren't being enforced or they're being under-enforced, and we're filing creative lawsuits to maximize welfare based on the legal status quo. But as we're doing that, we have a longer goal in mind, and that is, if laws are a reflection of what we are willing to accept as a society, we need to begin changing hearts and minds so those transitions in our legal standards can happen. This is a longer journey that takes time, and I respectfully submit that animal law is a very useful place to do this, because not only do we have the opportunity to win for animals in the courtroom, we have the opportunity to use litigation strategically to educate the public about animal issues and raise very important questions. So with that being said, Cedar's case is pending. If you'd like any case updates, please follow us on social media. My email's up there. Please email me. I also want to make a plug that if you're here and you're interested in animal law, which I have a hunch you are, and you live in the area, I have the honor of serving on the executive committee of the newly formed Los Angeles County Bar Association's animal law section. We are educating the bench and the bar on animal law issues, so please find me if you would like to join us. Thank you for your time.
Right. The PowerPoint is appearing in a moment. There it is. Lovely. Thank you so much. Excellent. So I'll be discussing the law around emergency relief and rescue, which is a phrase that may be novel to many of us, because this is the result of trying to find a way to encapsulate a lot of the topics that the other 2 panelists have touched on, and a broad range of issues. So what do I mean by emergency relief and rescue? I mean all of the various ways that as humans, we may respond to animals being in danger, but not simply intervening for an animal in an emergency. Because in and of itself, that is not necessarily a legally notable phenomenon. For example, if an animal that you own, that you have custody of, that you have control over, is experiencing an emergency, you can intervene. I intervened just this past Monday to take one of my canine companions to the vet because he ended up beneath the other 2 larger dogs, sprained his leg. He's going to be fine. He's very resilient in his heart. He's the largest dog. You can also intervene generically for animals at large. If you are wandering down the street and you see an animal walking by, dog, cat, what have you, that looks ill, that looks sick, you can whisk that animal off to a shelter. The caveat for some wildlife that we will discuss in a moment. So really what I mean by this is responding to a non-human animal in imminent danger by providing some ameliorative intervention, relief or rescue. So either getting the animal out of that dangerous situation or relieving whatever is causing the danger in a way that would otherwise be wrongful, because this is the part that makes it legally interesting, in a way that might otherwise implicate you in experiencing some civil or criminal exposure to liability. We'll do that disambiguation in a moment. Ignore that bullet point for the moment. Something I think it's important for us to think about as we talk about this is, for any given type of emergency relief and rescue, we should consider, how is this legally structured and situated? So for example, are we talking about a right? Are we talking about a liberty? What do we mean? It's this kind of Hoffeldian language that I understand makes lawyers really popular at parties, because we like to discuss the minutia of things. And we think that, Victorian legal icon Wesley Hoffeld is really where it's at least I do. He's pretty great. Why this is important is because when we talk about emergency relief and rescue as a right, for example, as right to rescue, and we don't question what that means, we are eliding some really critical elements. For example, we aren't asking, if this is a right, who does the right attach to? Does the right attach to a human? Or does the animal have a right to be assisted? Does the animal have a right to be removed or relieved? Or is this a liberty that a human has that doesn't impose any obligation on anyone else? Also, it's important to think about what impact these efforts have and what we want them to have on society, culture, law, and of course, the animals. So a few key considerations as we get into this. First, I'd like us to disambiguate between animal harm, animal maltreatment, and animal cruelty. Today, when I say animal harm, what I'm talking about is an animal experiencing something harmful, something injurious, something negative. When I'm talking about animal maltreatment, I'm talking about animal experiencing that because of human action or inaction. And then when I'm talking about animal cruelty, I'm talking about yet another subset where that action or inaction is a criminal violation. So there are an array of things that humans do to animals that are negative, that we can say with confidence animals are not fans of. That's animal maltreatment, but not all of that is cruel. And that distinction is going to be legally relevant. Go back one. And again, I think it's important for us to focus less on the how of the animal is relieved and rescued and more on why and what around liability. Because again, that's really what makes this legally distinct and interesting. There's no huge legal question in intervening on behalf of your own animal or a otherwise unowned animal that no one has an interest in. There is a lot of legal complication in intervening on behalf of an animal that someone else has a property interest in, or a trust interest in the case of the state or a tribal government. So why do we do emergency relief and rescue? Why are we talking about this? What do people who engage this look to have take place? Acknowledging that actors have a lot of individual motivations, I think we can broadly break this down into 4 areas. One is the notion that there's a categorical imperative to respond, that there's something bad happening to an animal, and we should do something to keep that bad thing from going on. And that might be heightened. The categorical imperative may be heightened in some arguments if the bad thing that is happening is being done because of a human. Again, if it is not just harm, but maltreatment. And then there are strains of argument that indicate that the categorical imperative is even stronger when that maltreatment constitutes cruelty. In other words, when it is something that society says is so inappropriate that it constitutes a crime. Sometimes this is framed as an effort to strengthen animal protection law or enforcement. For example, strengthening animal protection enforcement by revealing what is happening or by shaming law enforcement into themselves intervening on behalf of animals, something that I think in common parlance we refer to as doing your job. It might be about strengthening law by demonstrating that existing laws aren't sufficient for animals because the conduct an animal was rescued from was maltreatment, not cruelty, showing that the law doesn't do enough to protect animals from suffering at human hands. And certainly there's a lot of effort and a lot of rhetoric devoted to how this might generate new animal-forward case law. And what I mean by animal forward, my apologies to those of you who heard me talk about this yesterday, what I mean by this is a jurisprudence that surfaces the experience and interests of animals and treats them as being legally cognizable and weighable. We can have a separate argument about how much we weigh them, who we weigh them in relation to. It's sufficient that the law can recognize them and account for them. And that is the fundamental core mission, I would argue, of animal law, and is really central to this question. Now, you may be wondering, you mentioned revealing a maltreatment. When are you going to talk about ag-gag laws? Dear listeners, I am not going to talk about ag-gag laws. This is not an ag-gag podcast. There is a whole series of conversation around that. You can look at some previous animal law conferences online for a lot on that. The reason I'm not talking about it is when it comes to just revealing what is happening and not removing or assisting an animal, we're dealing with a different area of law. We're really dealing with free speech issues, and I can't cover that in the next 15 minutes. So we're going to focus on the removal and the assistance and the liability piece. Yes, there it is. So how do you handle the liability? How do you handle the fact that if you take an animal that someone else has a property interest in, or you do something to that animal, that person, that government might be unhappy? How do you avoid or respond to that liability? One option is to have a liability shield that says under XYZ specific terms, congratulations, your emergency relief and rescue is not presumptively wrong. You did nothing problematic. The second is to defeat the liability, to say, yes, it's presumably wrong that I took a piglet, a rooster, what have you, but I have a defense that will overcome that presumption of wrongfulness. And the third outcome is to lean into it and say, yeah, I took your pig, I took your piglet, I took your rooster, took your koi. That was wrongful. Let's see what the outcomes are. And either you accept them or you try to mitigate them. So 5 broad categories of emergency relief and rescue, and I'll go through these in turn. And they're all about how we get this stick figure dog out of an unfortunate scenario to what I'm sure is a very safe ride on the back of a moped. So the first that I'd like to talk about is via discretion. And this really relies on what in many ways is the reverse of the really striking FBI disproportionate response that Vanessa mentioned. This is an emergency relief and rescue liability solution that depends on the state, either law enforcement officials or prosecutors, not pursuing charges, or in civil situations on a plaintiff not suing you. As you know from your studies of law, depending on adverse parties to be kind and not pursue action against you sometimes works, but it's not a surefire solution. And it's certainly not something you want your clients to depend on. But to the extent that it's relevant, when it comes to state action, there is some guidance that indicates that there are scenarios where it would be inappropriate for the government to act. So for example, the ABA model rules for prosecution indicate that prosecutors should be thinking about what harm was actually caused, what the impact of prosecution or not prosecution would be on public welfare, and whether the public's interest can be vindicated through some other remedy that doesn't involve the ferocious power of the state. And finally, you should only charge if you believe that's in the interest of justice. So in a scenario where you don't think it's in your interest of justice, where animals have been helped, not harmed, where you don't see an injury occurring, you might arguably find, as a public attorney, as a prosecutor, that there is reason to non-prosecute. Speaking of the state, there is an area of emergency relief and rescue that involves the government acting to do that emergency relief and rescue, i.e. the state shows up and gets the animal out. Now, if there's a search warrant involved, this is not legally interesting because if there's a search warrant, we know that's a cut and dried legal issue. But what if there is no search warrant? This is where it gets exciting. If there is no search warrant, can the government yoink an animal out of danger? That's the technical term, yoink. And the answer is maybe. So the most interesting chain of cases on this is State versus Fessenden. I would encourage you to look at both the appellate and the Supreme Court opinions because they reach different conclusions. The appellate court in Oregon says, yes, you can yoink the animal out of imminent serious injury or death unless that harm is being inflicted lawfully. And so in that case, that applies to cruelty, maltreatment, or harm. It doesn't matter whether the injury or death was caused by a human or not, as long as it's not being done lawfully. So if an animal is in a burning building, whether that is arson or not, you can yoink the animal out. If an animal is being criminally abused, yoink. If the animal is going to be lawfully slaughtered, no yoink. You've got a maltreatment issue there. The Oregon Supreme Court says, we're going to decline to comment on the appellate court's holding. Instead, we're going to give you an alternative holding that says that you can yoink animals who are victims of crime. So in other words, specifically restricting it to cruelty. No general harm, no general maltreatment, cruelty only. So the appellate is harm and cruelty, no maltreatment. The Supreme Court is cruelty only. Other jurisdictions vary, but usually hew closer to that Oregon Supreme Court holding. But one of the things that's interesting here, I think, is that there is a recognition built in that preventing animals from suffering injury and harm is important because of the animals themselves, not because of whether their owner feels good or bad about them suffering injury and harm. There are statutory laws that allow for emergency relief and rescue that create liability shields. And these often are referred to as dog and hot car laws. I'm going to speak about it more broadly because many of them apply beyond dogs. And typically they work something like this. If an animal is in a vehicle and that animal is unattended and can't exit on its own, and you have a good faith, reasonable belief that the animal is in imminent danger, then you can use the least force necessary to remove the animal if you notify law enforcement or first responders as soon as practicable, and you remain nearby with the animal until you turn the animal over to the government or the owner. If you do all of that, congratulations, you have a liability shield, you are immune from criminal or civil action. As you can see, there are a number of states that have some variant of law like that, but there are complications. So for example, which animal? Some states restrict this to, for example, dogs or cats. Some states specify no farmed animals. California, for example, I believe specifies that this law has nothing to do with the transport of animals for farming purposes. But having established the principle that you can create laws that allow civilians, bystanders, to intervene for animals, you can amend them to expand them or narrow them. You've cemented the notion that that is a valid thing for the law to do because it's important for the animal's experience. That's an animal-forward approach. Another huge complication is how informed is the public or law enforcement? Two quick anecdotes to illustrate this. About a day after Oregon passed their version of this law, a citizen was walking through the Pearl District. If you've been in Portland, it's a very upscale shopping area. She witnessed a dog in a car, couldn't find the owners. The dog was panting. It was a hot day. She got a tire iron, smashed the window, but only after she was informed by someone that she didn't have to watch the animal die. It took someone telling her that this law existed. The owners showed up. They said, "Thank you so much for saving our animal. This is wonderful. We would so much rather have our beloved dog than our window." And then there are issues where law enforcement is unaware. I know there's some people in this room who, as part of an unexpected practicum in animal law, were recently in a parking lot in Portland and witnessed an animal, a dog in a car, and contacted law enforcement, contacted the park authority, contacted the organization that should be running that parking lot and said, "You're supposed to be responsible for taking this animal, for doing something." And they all said, "No, it's not our job. even though by statute, it is their job. Fortunately, I'm pleased to be able to say that the individuals responding to this, the animal lawyers responding, knew the law, smashed the window, got the dog out. Unfortunately, the humans were upset and law enforcement didn't know that this law itself existed, pointing to how this kind of statute requires education to actually work. But again, it implies the importance and centrality of animal interests. And perhaps the most recently high-profile version of emergency relief and rescue is to openly violate the law by removing an animal and then defending at trial. This is where a civilian actor engages in emergency relief and rescue involving some kind of criminal conduct, typically trespass and larceny. This is often referred to as open rescue, a concept really pioneered by activists in Australia that consists of very visibly and openly, without hiding your identity, often broadcasting your identity, engaging in some sort of direct action on behalf of animals, essentially daring the government to come prosecute you. And the notion is that you do this, and then you raise an affirmative defense. And that affirmative defense, if you're able to raise it, I know in Mary's case, they weren't able to raise that defense. The affirmative defense would typically be justification. Every jurisdiction has a slightly different version, but usually it goes something like this. Yes, I did all the elements of the crime, but doing so was the best alternatives. This is why this is often called the lesser of evils defenses. So you need to really actually believe that there was imminent danger. You can't just make it up after the fact. The harm that you're doing needs to be less than the harm you're preventing. And usually that needs to be as a matter of law. And if you're looking for cases on this, I would point you to Wichita v. Tilson and Hill v. State. These are both cases where anti-abortion activists argued that trespassing on abortion facilities or killing abortion providers was justified. And the state said, no, it is not, because abortion is legal. And while you may not like abortion, while you may feel that abortion is a huge harm that outweighs the life of a doctor, the law doesn't see it the same way. And so I think it's important when we are operating within the law to recognize what the legal space around justification is. And finally, there needs to be no less harmful alternative. So could you get the animal help without causing the injury you did to the person who has property interest in them? So what are the complications? Well, one is, are you going to be allowed to raise the defense at all? Or will the government say, will the judge say, well, as it turns out, you can't raise a justification defense on behalf of animals because they aren't someone's, they are some things. I would argue that there's something fundamentally flawed with that analysis, given that, recall, we actually have statutes and case law about how animal interests matter. And in fact, it's the entire reason animal protection law exists in the modern era. But this is an argument that's ongoing before the court. And in fact, the best way to get case law, if you were looking to do this, is to be prosecuted and convicted. Because having the trial court let you raise the defense and prevailing on that defense at trial doesn't build precedent. The best way to do it is sadly to eat the charge, be convicted, and then appeal to try to get something on the record from a precedent building circuit. Further, your affirmative defense may not address all of the charges. For example, if you're being charged with both trespass and larceny, trespass for entering a research lab or a farm or a pet store, and larceny for taking an animal out, your affirmative defense might work on the larceny for getting the animal out. The question is going to be, why did you trespass? How did you know an animal was in imminent danger right now before you went in? And it's going to be very hard, therefore, unless you have some sort of inside informant, some sort of undercover video, some additional factor, it's going to be very hard to argue that the affirmative defense applies to the trespass charge. And finally, and this is very important because this often gets misrepresented in popular media, this kind of affirmative defense, even when it works, does not make the specific kind of underlying emergency relief and rescue presumptively lawful. An affirmative defense says, the thing that I did is presumptively wrong, but I had a really good reason, a reason so good that society is willing to accept it. It doesn't say the thing I did was never wrongful to begin with. And I think that's an important distinction when we're talking about animals and their interests. Finally, of course, you can look for a jury nullification verdict where a civilian actor engages in emergency relief and rescue, they are prosecuted, and the jury declines to find them guilty, even though the legal elements were all shown beyond a reasonable doubt and no affirmative defense was raised. Your jury is always going to be the figures on the left, not the three cats in the jury box on the right. So be advised and act accordingly. Although I understand there are arguments that, at least in one notable case you've already heard of today, the jury, while they found on the elements, was also thinking about the experiences of piglets doomed to die in a factory farm. So some closing thoughts, because I'm down to like 2 minutes of talking and then we're going to do Q&A. Closing thoughts. I think it's important to match the goals of individual emergency relief and rescue efforts up with the risks and the outcomes. And as I've discussed, there are a lot of different goals you can have when you're doing emergency relief and rescue. If your goal is simply getting animals out because you believe that's the categorical imperative and you do not care what the risk that you take is, fine. Now, you may not have a lot more additional analysis to do as long as you are going into that with your eyes open. Follow your bliss, but don't follow your bliss blindly. Know the liability you're exposing yourself to and know what the potential outcomes could be. If, on the other hand, you are trying to generate new case law that recognizes a justification defense for animal health and well-being, you do want to do legal analysis. For example, you probably want to make sure that the thing you are intervening with is, as a matter of law, harmful. You don't want to intervene in a maltreatment scenario because that's not legally the same kind of harm as a crime. You would have a stronger case if the thing you are intervening with, the animal harm, is criminal. Be aware, again, of the risks. And there are risks both personally and strategically. So strategically, one of the goals of emergency relief and rescue is to raise the profile of these cases and shame the government into acting in ways that the person engaging in it would like. Sometimes that's passing better law, sometimes it's enforcing the law, sometimes it's foregoing action, foregoing prosecution, saying I'm not going to prosecute people who remove animals from harm. If that's your goal, be aware that the more the state forgoes, the less likely you are to get case law, because you need a case and probably a conviction to build the case law you may be looking for. And also know that you are putting yourself personally at risk in a variety of ways when you undergo this action. And you need exactly what Mary described, which is someone whose specialty first and foremost is defense work. If you are engaged in something that exposes you to criminal liability, you want a criminal defense lawyer. There's a world of animal lawyers out here who are happy to help animal issues. I do work with prosecutors, victim rights attorneys, the defense bar, judges, anyone who's a stakeholder in the criminal justice system. But I, for example, am not a defense attorney. I am not the person you want taking that case. You want Mary, because she is an expert at that. And you want to know what the collateral consequences you're exposed to may be. If you are in law school, if you are an attorney, are you aware of what the implications may be for your bar card? And take that into advisement. Again, don't go into this with your eyes closed. And I think when we talk about emergency relief and rescue, any of the kinds, whether they are lawfully permitted or not lawful, it's important that we be transparent and honest with each other about it. As Bob Dylan said, to live outside the law, you must be honest. And I do hope that you would all agree. And with that, I think that brings us to some question and answer. Thank you. Excellent. Yes, you know the drill, I believe. Approach the mics as you will. And we've got about 15 minutes for Q&A, and I'll be glancing over there for anyone online. Yes.
Hi, this is actually a question for Vanessa. My background is in companion animal law, puppy mills, and some farm animals. I know nothing about the 4-H program. I was wondering if you feel like, and I've heard about this case, and I believe there's been some other cases that have been in the news where, you know, an animal was either they were trying to take away from a child or some other issues. And I was wondering if you feel that since this case and some other cases, there has been a movement towards either reforming this 4-H program, any legislation, regulations, any lawsuits where you feel like there's some movement in the needle to change some of these practices.
That's a great question. I'm not sure if how 4-H is hearing these issues, what's going on behind the scenes at 4-H. 4-H has a variety of youth development programs. The livestock slaughter is one of those many programs. I hope that there will be compassionate alternatives available. That's what makes sense. But I'm not up to speed on whether that's feasible.
Mm-hmm.
Yeah, I'm not aware of any USA-based litigation around that. The closest I can think of is the United Kingdom has a program similar to 4-H, but in certain schools it's mandatory. And there are families that have sued on a theory of, I am vegan, I have a religion that requires me to not engage in this treatment of animals, etc. This is an ethical freedom of conscience issue, but I'm not aware of anything in the USA.
Okay, thank you.
Hi, both. This is a question for both of you. And I've heard you both talk about this briefly, and it was kind of interwoven in everyone's presentations today. But I was wondering what your thoughts are on the importance of storytelling, particularly in criminal justice work and animal criminal justice work, and how the identities and storytelling help win cases.
You should go.
Oh,
You have a
well,
great story.
well, here's what I'll say. I believe in the power of storytelling, and that boils down to the power of one animal. In the realm of animal advocacy, we have a lot of conversations of what is strategic, what is effective. There are certain schools of thought which say impact is measured on the number of animals whose lives are improved by a given intervention. But I think that model undercuts the power of story, which really does come back to the power of an individual animal. Because I can tell you that at Advancing Law for Animals, we are litigating cases which stand to have a tremendous impact on this field. We have a landmark case on behalf of animal equality against foster farms. We are in discovery. We are headed to trial. That did not get the news reaction that Cedar's story got. Similarly, we have a very impactful case against NIH involving government-funded animal experimentations. We just got a court order denying NIH's motion to dismiss, finding that we have Article 3 standing and statutory standing. That did not get the media interest that Cedar's story got. I've taken some time to look at the stories that have gone viral. And without spending too much time on it in this Q&A, when I sit here today, I am struck by Happy the elephant. I am struck by Naruto the monkey. I am struck by the right to rescue cases, which center around a small number of animals with names. So to me, the power of the story comes not from the number of animals impacted in a given case. It comes from a very compelling narrative about one animal. And that's why I think it's really important that we have these holistic conversations about what is impactful. And it's my position that it's beyond mere numbers.
I agree with that. Absolutely. I'm going to shamelessly borrow or steal a phrase from Kathy Hessler about one of the fundamental duties of attorneys, which is that we represent our clients, we represent interests, but that involves representing their experiences and their stories. because at its base, the law is about experiences, interests, and the weight we give them. There is a mechanism that's built up to govern how we weigh that, to make it predictable, to make it rational, to make it hopefully as just as we can. But at the core, it's about an experience and it's about a story. And I certainly agree that the impact individual stories have can far outstrip that individual animal. And I think that we see that when we think about the cases you remember about animals from law school, and even non-animal cases. The ones that stand out are the ones that have strong stories. So I'll look out for an angry, effective altruist out in the corridor looking to punch me in the face about that. But I think that's the truth. I think that individual stories matter a lot and end up having a huge impact. And I think Mary can speak to this if she's on the call still. I think Mary can speak to this about your case.
I am absolutely here. Yes, I think in all criminal defense work, you have a machine going against an individual human being. It is the state of Utah or the state of California against the defendant. It's the whole state against you, or it's the United States of America against the defendant. And people who are watching the nightly news about the criminal cases, you know, when they hear that the police have made an arrest and there's a prosecution of somebody because they're accused of being the Avenue's rapist, you don't sit there in your living room at 10 or 11 o'clock at night and say, now remember, he's innocent until proven guilty and he has a presumption of innocence. What you say to yourself is, thank God they caught him. And that's what that individual person is up against when they're going to a trial. And the only way to overcome that, I think, is to humanize that person and to tell a story of what happened to them and why they are where they are. It's critical.
I think on the converse, you can lose cases by telling bad stories. And I'll use an example of something I understand the prosecution did in Mary's case. As I understand it, in closing arguments, the prosecution wanted to explain to the jury why they felt it was not appropriate for the defendants to have taken piglets out of a factory farm. And they said, look, it's like you go to a supermarket and you see some dented cans and you know no one could sell those dented cans, they're trash. And so you take them. You can't do that. That would be stealing from the supermarket. And I'm going to go out on a limb and suggest that first, in a case where the critical legal question was, can the state prove the element that the defendants took something of value? Comparing the piglets they took to worthless dented cans was not a great strategic move. Also, I think that trying to tell the jury these two living creatures are interchangeable, inanimate waste products was unwise and so counterintuitive that it probably damaged the credibility of the rest of that closing argument. So yes, tell stories, make them good, believable stories, and make them true stories, and make them stories that, I think the counterpart to what Mary was saying about humanizing human clients, make them stories that give being to the animals. We don't have to get into whether you're anthropomorphizing them or not. You're simply acknowledging them as someone's. And that is huge. Animals have experiences that matter intrinsically. And we can surface that for clients, juries, judges, and lawmakers.
So I guess my question is, when you're comparing storytelling with the legal outcomes, I guess just from my own experience being involved in 2 open rescue trials, I remember at the legal Airbnb, like Mary, for example, Paul would come in and they were saying, oh, you know, I got a really, really good offer, really great offer. And as we know, Paul didn't take those offers and was acquitted, and that's great, but they were really good offers. And so, and at the same time, there's all this media attention and there's people coming and recording and podcasting. And I guess the question is, how do you strike that balance between what is best for my client and what is best for the movement? What is best for the animals, and what is, or is it more important for me to get this story out than to get this, legal outcome?
I'll let Mary take the first swipe at that.
Well, of course, I cannot discuss in this forum or any place the confidential communications that I had with my client about what offers were and whether they should not be accepted or whether they should be accepted. That's a confidential communication that I'm going to honor. But ultimately, it is a client's decision whether they are going to stick it out and go to trial, or whether they're going and I can give my best advice, and then my client tells me what we're going to do, and we do it. That's if the client says take the offer, we take the offer. If the client says go to trial, we go to trial. I have to say, my observation, I was absolutely terrified during this entire trial that Paul would be convicted of burglary, which is a felony offense, and that given the governmental hatred of him and some comments that had been made by various officials, I was terrified he would be handcuffed and taken immediately to jail if he were convicted, and that we'd have 60 days before sentencing and he'd be put in custody while we were awaiting a sentencing hearing and having a pre-sentencing report done, which would be the judge's prerogative to do that. So and when I said at the beginning of this, my lapel pin reads "Save the Human." I've been in a lot of jails and prisons over my career, fortunately, never as an inmate, and always visiting my client. And I could always knock on the door and say, I want to go home right now. And still, they were horrible places to be, and they are horrible places to be. And nobody should ever underestimate how truly awful jail and prison is, and that you are not going to find a lot of nice people there to be friends with, and that you have to think long and hard about whether you want to be in a jail or not. I don't think any rational human being says, oh, I want to go spend a few months or years in a prison. That would be insane.
I think that's exactly the appropriate framing. And to sort of expand it to your question about the movement, I think whoever is in the position of taking action and making themselves liable, being exposed to liability, they need to be the person that makes the call on how far they're willing to go and what it's going to mean. And they should be doing that with as much information as possible. So I would say, as animal lawyers, our role is to inform people about what the law is and how it works truthfully, and make sure that they've got a good defense attorney in this case. There's a good reason, I would argue, why Paul was better served having Mary than he would have with me, both because she's an expert in criminal defense and I'm not, but also because he already had, from many sources, extensive knowledge of what the movement had to gain and or lose from what was going on around that case. He needed someone whose sole professional responsibility was him and advising him on how to effectuate his goals. And then he can decide on what those goals are, tell Mary, and he has an attorney to help him carry it out. But you are absolutely right. It is a powerfully difficult thing to be in. And I don't think it is appropriate for anyone who isn't in those circumstances to be trying to make the call for someone else.
I'll just add that as a lawyer, your duty is to your client. And so in the space of impact lawyering, there might be other factors you're considering, but when it comes down to it, your duty is to your client. It is your client whose interests you serve specifically first and foremost. One thing that's interesting about animal law in the civil context is, as many people here know, sometimes animal lawyers represent animal advocacy organizations. And in the course of litigation, an animal lawyer might have a different view on the best possible outcome than the animal advocacy client. So I can't speak to criminal defense, but from the civil perspective in animal law, if you are an animal lawyer, it's so important at the outset to speak with your client about what is it that you want, what would you want to settle for, what would you be happy with, and get very aligned on goals and expectations. Because once that case commences, as a lawyer, your duty is to your client.
Yeah, and on the criminal side, the state has their duty to pursue justice according to the state's format, to try to secure a conviction in a case they believe is righteous. The defense counsel has a duty to first avoid a guilty verdict and then mitigate it if it happens. And in a human, where there's a human victim, that victim can have their own attorney to represent them. I think in cases where there is an animal victim, if you are fortunate enough to be in a position to be able to advocate for that animal's interests, you have a ethical obligation, if not an actual professional duty, to really think long and hard about what's good for that individual animal, separate from your political aspirations or the movement or larger goals. It's about that client or that quasi-client in the case of animals.
Hello, this is a question for Mary, and I wonder if she had the opportunity to talk to the jurors after the verdict and what they said.
Yes, I did. I talked to a couple of them at length, and they've also spoken publicly, and I believe that their public disclosures are on the internet someplace available. But from what I understood, the jury began deliberating, and what this all came down to, so that you understand the legal posture of the case by the time it went to the jury, was that my client had been charged not with trespass, but with burglary. And the definition in Utah of burglary is the breaking and entering into a building with the intention to commit a felony on the inside, or with the intention to commit a theft on the inside. And the definition of theft is taking anything of value. And our defense in this case was that these pigs had no value. The two piglets taken were in such dire medical veterinary circumstances when they left the building that they were valueless. The prosecution introduced evidence that on the Chicago Board of Trade, on the day they were taken, wiener piglets were trading for $42.50 a pig. And these piglets required hundreds of dollars of veterinary care, very individualized veterinary care each, in order for them to survive. There was evidence that all farms raising pigs as a crop, a financial proposition, all such farms across the board suffer about a 15% loss of piglets before weaning because they die in the process. And our argument to the jury was these pigs had no value. These two piglets were just about to join that 15%, but for the fact that somebody carried them out of a building and took them to a veterinarian, and arguably foolishly spent hundreds or thousands of dollars more than the pigs were worth to see that they got necessary veterinary care. And the jury went through the analysis and said, yep, these pigs were going to end up in the trash can. And ironically, I think the prosecution's argument that these were dented cans actually played against them, because I could say, so if you open the back door of the grocery store at night, you don't kick it in, you just open an unlocked door and you walk in and you remove the bent cans that are in the back of the grocery store to dolly them out and take them with you because they're stacked there to go to the trash can the next day. Is that a burglary? Have you taken something of value? Arguably not. And the jury said, yep, we don't think these pigs had any value. It had no economic value. And the jury went right down the line with the legal analysis that we laid out.
Yeah, I'm under the impression that unfortunately, I think since then Utah has some legislation that will sadly close that defense. And I think and we are out of time for questions, so I'll simply wrap up by saying that this panel is part of the larger conversation that you're having all through the conference. So you'll hear people talk about legislation, local activism, federal rules, the whole gamut of law. It all interconnects. So the work that happens around emergency relief and rescue that we've talked about here impacts legislative work. The work that Vanessa is doing on behalf of Cedar's family impacts search and seizure law, but also impacts damages calculations. It's all an interconnected legal web, and we are thrilled that you are part of it. Thank you to my panelists for joining us.